All right, let's proceed.
Good morning, Your Honor. If it please the court, Attorney Harvey Hafetz, my associate Scott Semple for Lighthouse, and Mr. Alves. Your Honor, this involves the procedure by two state agencies, Division of Administrative Law Appeals and the Attorney General's Office. Also, the Division of Occupational Safety, now known as Division of Labor Standards, DLS. I call it DOS because that's what it was throughout, and all the correspondence is DOS. In December 2004, DOS issued a schedule of wage rates for a public construction project in Rentham, Mass. In July 2006, the Attorney General's Office issued 4 citations to Lighthouse, 3 of them for alleged misclassification of work. Lighthouse appealed pursuant to Chapter 149, Section 27C, to DALA for a hearing. We had the hearing in 2007, but before that, 4 months after the citation, the Attorney General specifically asked the DOS for an opinion. Their letter was phrased, "The question is whether certain work is under the jurisdiction of the masons/bricklayers or the laborers. Both collective bargaining agreements lay claim to the work." 5 months after that, DOS responded and simply said, "Masons."
So your argument basically is that the DOS should make these task within classification determinations before the bid.
Section 27 mandates it.
Well, is this something that would cripple DOS and the Prevailing Wage Act if that were to be done at that level of specificity?
Commissioner Laura Marlin states in her affidavit that's before you, I think it's about Record Appendix 168, that they feel that it's impractical and they haven't got enough staff, and it might make an overly large document. But if you look at the descriptions...
It has to be done project by project.
Yes, it does. And if they don't do it project by project, then the issue is it a regulation? Not to mention issues as to whether it's wrongful delegation of legislative authority. All these issues preclude what they are now doing.
But Mr. Hafetz, I'm looking at your complaint, and I guess I'm having some trouble. I understand the substance of what you're saying, but I have some trouble seeing that that's what you're complaining about in your complaint. It seems to me that the basis of 3 and 4, as Judge Kaplan suggested, really were that the chief administrative magistrate didn't have the right to replace the what the hearing officer did.
Absolutely, Your Honor, that is an issue. What
how about
DALA
the
did
issue?
is completely out of their performance, but there is also this very significant issue
Where is it in the complaint?
Paragraph 32, Your Honor.
I'm looking at that, but the relief sought is to get rid of the chief's decision.
I think the third count actually asks for the hearing officer's decision, Magistrate Fletcher, and count 4 does seek to get rid of the decision by Chief Magistrate Taylor, because her decision states in part, now you're on notice, from here on you're bound by this determination that's already been made by DOS.
Well,
So she's looking prospectively, which, as Judge Lank just mentioned, you can't do because it's got to be job by job.
But when you were in the administrative process before DALA, the relief that you were looking for was a voiding or a vacating of the citations.
Yes, sir.
Yeah. Now, focusing on 3 particular citations, you won, didn't you?
We did, Your Honor.
Does it make any difference what the reasoning was?
Very much, Your Honor. The decision by the hearing officers...
Does it make your win any more poignant, or...?
Yes, Your Honor. We've got 8 more citations now pending at DALA that have been stayed waiting for this case to be decided.
Got another case. You have another case pending. in the Superior Court.
Given a finding on the specific facts of whose work is it in the field, and a firm decision by the hearing officer after a careful review and statement of the facts and her view of that, this is laborer's work. Now, if we can plead in those other cases that that decision presents an issue of issue preclusion, it will make our position a lot better going forward. Furthermore, just being told that we didn't have notice, which was the basis of Magistrate Taylor's decision of vacating the citations, really will do my client no good going forward. What he needs to know is that he can still make the evaluation, as the hearing officer did, that this is unskilled labor, and he can plan to perform those unskilled tasks with laborers.
Do you agree with me that the department could, by regulation or through some process, clarify which work falls within which classifications for all jobs?
Most of the jobs, I believe, Your Honor, like electricians and plumbers, are really subject to regulation that's already there by their controlling administrative process. Carpenters, masons, they are not. And in this instance, very specific, the Attorney General acknowledges this is laborers' work. It's in the laborers' union agreement, which is supposed to set the wage rates under Section 26. But it's also in the masons' agreement.
So your argument is that, and I think it certainly makes sense, these determinations should be made in advance, not after the job is halfway down the road.
Section 26 mandates it. What they're trying to...
6 or 27?
No, 26 sets forth that the union agree... I'm sorry, you're absolutely right, Your Honor. 27 says that the schedule of classifications of jobs will be set forth before the bids, included with the bids, and then incorporated in the contract. If this is binding, as the Attorney General and DALA maintain, then the whole procedure under Section 27, the mandatory pieces, are a nullity.
But didn't Magistrate Taylor essentially agree with you and say that you can't be required to look to or rely on something that happens after the contract is signed?
She did it on a notice basis, but and while I agree with her on that, she also turned around and treated it as though it were a regulation and said, now you're on notice, the next time you've got to use masons to do this work.
But you're trying to convert the DALA proceeding into a forum for attacking the merits of the reasoning that the commissioner entered into when setting the rate, the wage rate.
We don't know the reasoning. If you want to discuss...
Yeah, but that's not my question. You're trying to establish a forum where that reasoning can be challenged.
Absolutely.
Before DALA.
Absolutely, Your Honor.
And our case law says that's not the place to do it. It's the commissioner's decision is unreviewable.
If I may, Your Honor, there is a section, comes after 27, 27A, which provides for an expedient appeal, but it's being viewed much too broadly. It's what contains the term final. It doesn't say the determination was final.
But you're creating a situation in which our case law says review is by certiorari. So you're reviewing an error of law. You want a much more favorable forum where the standard of review is entirely different.
I want a forum where I can argue this on the facts.
You can do that under 27.
How?
You're suggesting under 27A, and your 27A has to be put in
I'm
context.
suggesting under 27. If there was an ambiguity, if there was something missing in the terms of the contract, don't you have an obligation before bidding on the contract to either get that term resolved through an informal letter or take an appeal, which can be resolved within, 3 or 4 days?
Your Honor, this is the way it's been done, according to the Attorney General, for 20 years.
The Attorney General says, though, that what's happened is that there is a letter from DOS, as you put it, which is explaining something that's prima facie evidence. It's not binding. That's what she says. She says,
That's-
she goes back to saying that that's an interpretation of what they've already said.
Your Honor, there is no evidence of a prior determination. Determination is the word, the term that Section 27 uses.
If there's no determination, there's no contract.
Your Honor, there is a contract with rates stated, and there's a case, East Coast, from 1996 by Judge Bond, where he was dealing with whether it is too vague to simply say masons, laborers, and his conclusion was that contractors will use custom in the industry to understand who is doing which work. And that's a piece of what we tried it on and presented it, although skill is also, in our view, a huge piece of that.
In the work that you're contesting here, was contained in two separate collective bargaining agreements, one of them attributable to the bricklayers and the other one attributable to the laborers.
Yes.
And that was definite enough to bid on a contract?
Yes, because my client's non-union, so he's not even cognizant of those documents at the time he bids.
But that's
Although
the
he-
process by which the rates are set. It's the union
And we're
contracts.
given those rates. We're given those rates up front before the bids. The question is the work within classification that we're not being given, and what the Attorney General and DOS are now doing is saying, oh, 2 years later, we're going to substitute this opinion for what should have been under Section 27.
So what you're saying is that letter is neither a regulation nor a determination.
Absolutely not, Your Honor.
Where is the regulation? Where is the determination? That's your question.
It's not being made by DOS, Your Honor.
But you could have asked before, right? As Justice Spina is saying, you could have asked when you get this thing and you, it's not clear whether it's laborers or bricklayers. You
I
could have
agree,
asked.
Your Honor. The catch
Is it clear
is...
that it's not clear? Or are you suggesting that
is
there should be
clear.
a regulation?
Also, the Dallas statute is clear that the hearing officer's decision should control. But our client, using his own knowledge and 40 years of experience, knows which work belongs to which.
That's why I'm asking you. Was it clear that it's not clear? That is,
To
did you,
him, it's
looking at this,
If you look at the hearing officer's decision, you will see it's absolutely clear on the functions involved. That work is really completely unskilled, and therefore he determines in bidding that he's going to use laborers, and he's the low bidder. He wouldn't be here if he weren't. The town gets the benefit of that.
So why shouldn't we let this case pass and consider the issue in the next case that's percolating up through the system where the issues are really more adequately litigated and they're joined?
Because one, my client's already convicted. A citation,
Wait, okay, but it's a civil citation, so let's not use that word.
Your Honor, he has to put it into DCAM every time he wants to be certified. The unions attack him every time he bids a job and say, look at these citations he's got outstanding for not paying his employees.
Yeah, but that's for an entirely, the citation on which, that issued in the case is one that issued for reasons having nothing to do with what we've been talking about for the last 10 minutes or 5 minutes.
But they're trying to substitute for what they are supposed to do under Section 27 with a letter after the fact.
But the citation that you're talking about was based on fact. Your client couldn't have won under any circumstances. It's a strict liability statute, and he was claiming clerical error.
Your Honor, if I look at the overall wage rate cases under 149-151, this court repeatedly has said the purpose of that statute is to avoid undue delay, to make for prompt payment. That doesn't say the man has to be paid 5 o'clock Friday afternoon or you violated the statute. Why should there be a stricter standard under the prevailing wage law? And we're not worried about the $500 citation.
That's not a procedural question. You're now arguing the substantive law.
Your Honor, the term that Your Honor just used, strict liability.
Yeah.
that means that intent is not an issue.
That's right.
This isn't a question of intent, it's a question of how broad the statute is and whether the wage rate provision that this court has said is prompt payment and not unduly delayed has some margin in it that would account for a clerical error that is promptly corrected.
Counsel, I have to interrupt you. Your time is up.
Thank you very much, Your Honor.
Good morning, Your Honors. My name is Richard Heidlich. I'm the Chief Administrative Magistrate of the Division of Administrative Law Appeals. I'm also a Special Assistant Attorney General for purposes of this litigation, and I represent the Division of Administrative Law Appeals.
So your position, in part, I take it, is that this letter cannot be challenged
That is not correct.
at DALA. It can't be challenged.
That's not correct. And if I may explain, Your Honor.
Sure.
The underlying issue in this case is who is going to decide what is the prevailing wage in the Commonwealth of Massachusetts for public works contracts. And the statute, we believe, puts that responsibility into the Department of Labor to the Commissioner. And we believe it is not in the responsibility or authority of a DALA magistrate to determine what should be the prevailing wage. Our job is to determine what is the prevailing wage and what it is that was paid and whether or not that was a prevailing wage.
Well, in order to decide the prevailing wage, you have to decide what work is within which classification.
That's exactly right. So there are essentially four
You say you can't do that.
four factual determinations that we need to make. Number one, what was the work that was done? And how many hours was that work done? Mm-hmm. What was the rate of pay that applied to that work?
I mean, as a matter of fact?
As a matter of fact.
Okay.
Okay? In other words, if you go back to the statute itself, the statute provides that the rate per hour, this is section 26, the rate per hour of the wages paid to mechanics and apprentices and so on, shall be the rate or rates of wages to be determined by the Commissioner as hereinafter provided. Section 20, that's 26. Section 27 says, whoever shall pay less than the rate of wages or the wages or the rate of wages as determined by the Commissioner has violated the statute.
Okay, but when you were listing four things, you said what work was done, how many hours, what was the rate paid? And I guess my question is, you have employee X who did this kind of work, worked for 15 hours, and was paid $1,000. It's that factual issue, right?
So the determination of the rate of the prevailing rate to be paid that was made by the Commissioner involves two elements. Number one, who is it that is supposed to do that work? So in other words, just to give an example, the question of laying brick. Who should lay brick? And the question is, that determination is we're saying is in the authority and jurisdiction under the statute of the Commissioner of Labor.
And did the Commissioner make that clear in this case before the contract was executed?
Well, I can't answer that question. That is not in our record because of the way the case was decided. But I would say this, Your Honor, that is the requirement. In East Coast construction, what Judge Bone had concluded was that because of the custom of the industry, that the contractors who are in the industry understand and know that bricklayers are the ones who are required to lay brick, and you can't have laborers laying brick.
But the laborer's contract in this case said that they could do certain things that the bricklayers' collective bargaining agreement said that they could do.
That's correct. So you have an overlap in claimed jurisdictions. I would also note, Your Honor, that because the Commissioner is required to set a rate that is no less than the rates set in the collective bargaining agreements, then the collective bargaining agreements are necessarily part of the decision that the Commissioner is making when he's setting the rates.
And they're on file somewhere that a non-union contractor can review?
Your Honor, there is no reason that a document that is the basis on which the commissioner has made a determination is not subject to a FOIA, so that any contractor can get access to any of the collective bargaining agreements that are being used by the commissioner.
What would they have here? They'd have two in conflict.
They have two in conflict, and therefore you know that there is going to be an issue. You know, as a contractor, you say they're two.
Which the commissioner should be determining
In
itself
advance.
without having to be prompted to do that.
Well, I believe that's correct, Your Honor. And where there is a conflict, it should be made clear
In
how,
advance.
in that contract, in advance, how that's going to be done.
Well, but the commissioner didn't do that in this case.
It's not so clear to me, Your Honor, if you look at the record, that determination was ever made. I know it's assumed. I know that they argue, but I do believe.
No, they say it didn't get made. Didn't get made.
I don't believe that I have seen any evidence or finding that that is true, or even if that was true, that the determination was not made. The commissioner did not glom onto the fact that there's an ambiguity here because you have two collective bargaining agreements that are in conflict. Therefore, he needed to make, or she needed to make a determination as to which one applied in this case.
So you agree that there was an ambiguity in the contract?
There was an ambiguity in the contract. If that is known or knowable by a contractor, the contractor has an obligation to determine what is the rate that's going to be applied. Yes, the commissioner has an obligation prior, if asked that question, prior to the issuance of the contract to clarify so that the contractor knows what it is that the rate is going to be that applies.
So you're saying that's the obligation of the person making the bid, the entity making the bid. I thought earlier you said it was the obligation of the commissioner to make it known.
It is the obligation of the commissioner to
Only
make,
on request, not when they're,
if the commissioner, without evidence and determinations, and we have cases in which the commissioner is deposed to determine how the classifications were made and so on. That is evidence that comes to DALA. The issue before DALA is not what is the best rate to apply or what is what skill is required. All we need to know is what is the rate that was determined by the commissioner. If we find as a fact that no rate was determined, and if we find that there is the contractor had no reason to know there's an ambiguity and therefore no reason to ask the question, then we might then, at that case, say there is no rate that was set, and therefore there's no violation of the statute because there is no failure to pay the rate as set by the commissioner.
So is it your point here that Magistrate Taylor did not, well, the Lighthouse argues that what Magistrate Taylor did was say, I've received a letter from DOS which says this is what the classification should be. It should be a masonry. I find that to be binding. And they say that's not fair because we did not have any chance to challenge that, and you can't accept it as binding unless it is done before we bid. What is your position on that?
My position is that the letter, however the letter may have been written in this case, the relevant evidence that should have been accepted by the magistrate hearing the case was what is the classification that was determined by the commissioner at that time before the contract was issued. If there is a determination that today that what we believe that the classification should be today, that should not have been accepted as relevant evidence in this case because it's irrelevant.
So you're saying that that document is binding only to the extent that DOS says before this contract was bid, this was our position as to classification, and it was known, or at least was available to be known.
The letter is not, to the same extent that no evidence is binding on a finder of fact, it is what it is. The determination that was made by the commissioner at the time the commissioner made it, that is within the jurisdiction and authority under the statute of the commissioner. We can't change that and say, it should not have been a mason that is doing the rubbing of brick because it doesn't really take that kind of skill. If the commissioner, before the contract was issued, determined that the the employee or the classification that would do rubbing of brick is a mason, then that is the classification that is binding on us. How that comes to us as to what that determination was, how we receive the evidence depends on what the parties do. The parties can depose the commissioner, they can submit the documents that show what the classification was made, and we make a finding of fact based on that evidence as to what it was that the commissioner did at that time.
So do normal contract principles apply here? If there is an ambiguity in the contract, it inures to the benefit of the contractor.
I don't believe that's true, Your Honor. I do believe that because it is a public works contract, and under the law that's cited in our brief, that a contractor who wants to participate in a government contract is required to affirmatively determine what it is what the rules are for that contract.
So if you had a case in which the commissioner, the DALA officer says, I've got in evidence this DOS letter, and it says, which was issued 2 days ago,
right,
and it says that this work is bricklayer work. Can the DALA officer say, I've got this letter, and it says it was bricklayer work, but I find as a fact that determination was not made before this contract issued. Therefore, contractor wins. Could the DALA officer do that?
Yes, Your Honor. If there is substantial evidence to establish that letter was stating a classification that was not a determination that had not been made, then and that finding makes sense.
So and
yes,
the
of course.
contractor could appeal from the DALA decision. Let's say that the DALA hearing officer says, commissioner's letter indicates, and I find that this classification was made before, and the contractor should have been on notice or was on notice, but the contractor can appeal that and say, that's just wrong. There's not substantial evidence to support the finding of the DALA hearing officer on that question.
That's correct, Your Honor.
But you said something else. You said, and there wasn't a basis to affirmatively obtain that by the government contractor at the time. You posed an obligation on the government contractor to also note that there was a potential ambiguity and seek it out.
That's
so
correct,
even
Your
if
Honor.
it hadn't been made, the next question, according to you, is that the government contractor then must also be found to not have been on notice that there was an ambiguity.
That's correct, Your Honor.
Counsel, we've got to leave it there.
Thank you, Your Honor.
Thank you.
Good morning. Carla Zarbo with the Fair Labor Division at the Attorney General's Office, and with me is Assistant Attorney General Bruce Traeger on behalf of the Attorney General. I wanted to clarify a point that was just addressed by my brother. There were essentially two ways DOS issues these determination letters, or for two purposes, one of which is
Determination letter, is that
a
what you called it?
determination letter issued by DOS or the Department of Labor.
This letter that came into evidence was a determination letter.
That's what we call it. Someone else might call it an opinion letter.
You ask for it after the case has been brought,
Well,
right?
again, there are two, when DOS issues these letters, they do them for two separate purposes. One is to announce new classifications, to give notice to everyone.
Don't they have to do that on a contract-by-contract basis?
They do, and sometimes it's industry-wide. For example, I know recently there's an issue percolating about solar panels, for example, something new technology or a new installation system method or something. They might do a new letter announcing prospectively, never retroactively, prospectively a new classification or a change in classification. And the statute actually calls for that. If you look at Section 27, it speaks to the commissioner may revise the classifications from time to time.
But I thought this letter was, in effect, an accommodation to the commissioner it is a report of what his testimony would have been had he been called to testify, and that's all it is.
That's exactly right. And as I was saying, there are two purposes. One is to announce new classifications, but the second is in the context of a litigation proceeding, including a DALA litigation proceeding, as proof of a prior existing determination. And that is the case here.
No, I'm hearing something different. I'm hearing that it has documentary effect, that it is an official document, which is not the same as saying this is a substitute of what his testimony would have been.
Well, it's proof of that determination. The letter itself is proof of the determination.
What if the hearing officer can disbelieve it, right?
If for some reason it's not properly
Evidence is-
authenticated.
No, wait a minute. That's different, though.
Okay.
I mean, is it just the substitute for oral testimony?
That's generally our intention at a DALA
Then
proceeding.
it's not proof.
Well, it's proof of that determination. They allow hearsay at the DALA proceedings. It is, as you said, an accommodation for the commissioner. Instead of making the commissioner come in, we have many, many hearings.
But if he had written the letter before the contract was signed, it would be an official determination that would be binding on the parties, wouldn't it?
Well, that would be true, but they also
Does it have the same effect at this hearing?
It does, because this is
doesn't
a
make sense.
It's a pre-existing determination. This letter, it's here in the record.
If it was a pre-existing determination, why wasn't it put in writing
Yeah.
then?
Yeah.
Well, there is a body of case law on that. There is a record of all of these determinations the commissioners have issued over the years, and the classifications change slightly from time to time. The commissioner was careful in making this determination letter for our use in litigation. If you look in the record at page 173, he speaks to the fact that he is attaching copies of the trade autonomy language for the relevant collective bargaining agreements in effect at the time the wage schedules were issued
When you
for
say
this
record,
project.
you don't mean the record appendix. You mean something
I'm
else?
sorry, I do. The record, the joint record appendix on pages 172 to 173.
Okay.
So it's not in our appendix.
Yeah, it is.
The letter is, but
Yeah, that's what she's talking about.
But are the prevailing wage schedules? You said, Bart, you said the letter that was submitted in evidence includes sections of relevant collective bargaining agreements in effect at the
The
time.
agreements themselves are not in the record, but they were enclosed with the commissioner's letter
But
at the
Chief
time.
Magistrate Taylor's findings don't really accord with that, because as I understand her findings, she says, this letter is binding upon me, but they didn't have any fair notice of it. And therefore, restitution is not being sought, and therefore a citation is inappropriate. So how could she find, as you claim she did, that there is a definitive pre-existing classification, and also find, but they didn't have any notice of it?
Well, the Attorney General's office does not agree with Dahla's determination in this case. We do take the position that we use these letters, we use them in civil litigation routinely as proof of the prior determinations made by the commissioner. We use them for, a summary judgment motion.
How is a contractor supposed to know about this prior determination?
Well, there is a body of these letters.
Do you know where, prior to the date of this letter,
This determination was
these
made?
determinations were made?
Some of these classifications have existed for many, many years.
But the point is the commissioner could go in a closet, make the determination, and leave the determination in the closet and nobody will ever know. It exists. So how does a contractor find out what the determination is?
Well, they are posted on their website on the internet. They're available to anyone who
Was
inquires.
this letter posted on the website before the contract was executed?
Not before the contract was executed. This letter was used in the litigation. This
Why
was
was
offered.
this letter used if, as you say, you could look on the internet and find a prior determination as to what clarifying the ambiguity between labor and mason work? So why didn't they just provide a copy of that, whatever it is?
On some occasions, we routinely ask DOS to prepare correspondence like this for litigation matters. And sometimes they do refer, they'll say, see attached letter from 10 years ago.
Are affirming that that is out there, that there is no ambiguity, there was a prior determination, that's what you're saying, and that this is just an affirmation of something that happened before that is online, even though no one has put it in this record or ever talked about it until you standing here today.
But can I just ask to follow up on that question? So whatever is online has nothing to do with this project. It has to do with prior projects.
Right, that's precisely why we ask for determinations letters that are project-specific for use in this litigation, for this time period, for this matter.
The made-up as you're going along quality, I think, that is troubling here, which is that, okay, there's no predetermination out there that is project-specific. So now there's a problem that has arisen, and there is something before DALA, and we need to have proof of what it is that is the correct classification. So we're going to get a letter produced now as to what the commissioner thinks is the correct classification, and we're going to say it's not just what he's coming up with now or she's coming up with now. It is actually reflecting what she thought about but didn't write or say or document when the contract was pre-bid.
Well, when you say didn't say or document, that's not the case. Every time the commissioner issues a prevailing wage rate schedule, that becomes part of the bid documents.
Prevailing wage rate schedule does not include these
It does not.
tasks.
It does not list all of the tasks. It'll have a job title, for example, electrician,
Mason tender.
mason tender.
Mason tender is a laborer position.
they'll
A
have-
labor mason tender is what it's called.
They'll list all of. There's over 100
Got a
different.
bricklayer and a laborer mason tender, all right? And the distinction's pretty important on the wage scale. How do you make that determination, and how does a contractor understand it?
If a contractor is unclear, if they are uncertain as to what classification the work their employees perform, the burden is on them.
Who says?
Yeah.
Well, it's a strict liability offense.
No, but hold on. You say the burden is on them. How are they supposed to know that?
Well, they're bidding on a project. They're part of their labor costs, or a substantial portion of their contract is going to be their labor costs. It's important to them to know how much of their
But the commissioner doesn't have a regulation that says if you're unclear, you are entitled to seek my opinion, and I will give it to you. She doesn't have anything like that, does she?
But for someone who chooses to do business with the government, chooses to contract with the government, they have an obligation to find out what the regulatory scheme is.
Well, it
But
says
if you're responsible for the regulatory scheme, you have the responsibility for putting the information out that you're going to hold contractors accountable for.
And they do. Those rate schedules list over 100 different.
Of course they list, but the question is not the rate schedule. The question is where the work falls. Does it fall under this classification or that classification? Under the rate schedule, right?
So that's exactly right. So if someone doesn't understand what work their employees are performing, they should make inquiry. They don't
right.
have to do it formally. They could do it informally. through
You
a phone
submitted,
call.
there's two letters here. All right, they're different. One says it's this, and then the other one says, please, we're rescinding that prior letter.
Well, there's
Do both of these letters relate to a prior determination that was made?
I believe you were referring to Commissioner Marlin's letter, but if you look at Bob Prezioso's letter, that's in page 172 to 173.
And I'm looking at the next page,
Okay,
which is
the
the
next-
next letter rescinding the first letter.
But if you look on the following page, Record Appendix, page 175, it's actually a letter addressed to me from 2004, and it's regarding an applicability determination. This is what I'm explaining. There's a body of these letters out there that are available not just to contractors, but to employees, to anyone who's interested. So if there is an ambiguity, if there is an overlap in trade autonomy, people can educate themselves.
But explain to me why if there was a prior determination as to which category this labor went into, and March 23rd letter is supposed to be just a document, just a affirmation of a prior determination, how come there are two letters which are different?
Well, the new commissioner came in, Commissioner Laura Marlin came in, replaced Bob Prezioso, as is her ability to do under the statute. She changed the classification. She's entitled to do that as commissioner. She cannot do that retroactively. We certainly would never enforce that. That would be completely inappropriate, completely improper. A determination.
This is a new determination.
It's going to be new. It has to be new. It cannot have any retroactive effect.
Is it made in the context of any particular case?
I don't know that it had any context to a particular case. I don't know what prompted the commissioner to make a classification change. They're allowed to do that. The statute contemplates that the commissioner shall revise said classifications from time to time. It's in Section 27.
The classifications, going back to my earlier question, and don't want to miss it. It contemplates that there will be collective bargaining agreements that might change the classifications, right? So what good is a 10-year-old determination about what it was then.
That's exactly the reason we ask for new ones every time we have a litigation matter. We have a
You just said
determination
you
letter.
look to those old letters for government contractors to figure out what it is they're supposed to do in 2012.
If they're not certain what the tasks are, they should make an inquiry. There's a body of case law, not case law, a body of these letters from the commissioner that have.
You're saying that if they relied on a 10-year-old determination and it's now changed, but they don't know it, that they'd be okay?
Well, we don't have a
Or-
case like that here. We don't
I thought
have.
you said there were,
I think that would be a
just
better
confused.
argument for an employer. I think an employer would be in a far better position to argue a case where they relied on a commissioner determination letter that had never been rescinded. I think that would be a far better position to be in than what Lighthouse is arguing here. Here, the record indicates they made no inquiry whatsoever and didn't bother to even read the collective bargaining agreements. They decided to rely on their own
I'm sorry.
subjective interpretation about what's covered under these classifications.
The Attorney General's office, this is the Attorney General's office letter to the Department of, or DOS. Both collective bargaining agreements, that is the laborers and the bricklayers, lay claim to this work. So if you read the collective bargaining agreements, you would be, oh, that's interesting, okay, they both lay claim, which is your problem. So you don't know what it is.
Well, it's not that we don't know what it is. When we make a request like this to the commissioner, it's to offer, to get a response back, to offer as proof. The letters themselves are not the determinations, they're proof of the determination.
So there is a determination somewhere prior to this contract of this precise point available.
Yes.
Where?
Again, they have them posted on the internet. They have an appendix of topics of
Was it introduced in evidence in this case?
the prior determinations. No, no.
Why not?
Well, again, the rate sheets apply only to this particular project for this particular time period. And the commissioner's letter, the March 27 letter, deals with that King Philip High School project in Rentham during this 2004 bid period.
Is it
Ms. Zarbo, I
Kafkaesque?
have to interrupt. I'm sorry, you're way over your time.
Not her fault.
Thank you. Not your
Our
fault.
fault.
Thank you.
Thank you.